invitees with us. My name is Philip Jones. I'm a bencher of Lincoln's Inn, and I'm on the committee for the Black Books Society. We're very fortunate in Lincoln's Inn in having an extensive collection of manuscripts that were left to us by Sir Matthew Hale, who was a bencher and a judge in the 17th century. Today we have a talk from Dr. Ian Williams of UCL about the collection, preservation and use of legal manuscripts after the invention of printing. Ian has a particular interest in both legal printed books and manuscripts, so we're very fortunate that he's agreed to give this talk. Ian's also agreed to take questions, and the way we would like you to put your questions is to click the question and answer box, not the chat box. And then Nicola Pedovan will be reading those, and we'll put the questions to Ian at the conclusion of his talk. So Ian, over to you. Thank you.
Thank you, Philip. I'm just going to quickly share screen with everybody. As Philip mentioned, Matthew Hale left his manuscripts to Lincoln's Inn on his death. The first thing he said about his manuscripts in his will is the quote that was in the title of this session: "They're a treasure not fit for every man's view." What actually followed from that, though, is "nor is every man capable of making use of them." I think I'm going to skate over the idea that only people from Lincoln's Inn could understand Matthew Hale's manuscripts, although some of them are quite tricky. What I want to focus on is this idea of the manuscripts as treasure, something of particular value. And if they are treasure, well, Lincoln's Inn Library now has perhaps enough treasure to satisfy all but the most avaricious pirate or all but the most curious legal historian. The first law book that was printed in 1482 is a relatively introductory work on real property law, Littleton's Tenures, which is pretty well known. I've put up the 1591 printing on a slide purely because the 1482 book, like many books from that period, doesn't actually have a title page. It just begins with the start of the book, and in that sense is not that attractive to look at unless you are particularly into very early printed books. So this is just the first book printed in England. The fact that I could talk about it being printed in 1482 and that there's a 1591 printing would tell you how important this book was. It was constantly reprinted through the 16th century. And after Littleton had been printed, we start seeing medieval law reports coming out. We start seeing some other major reference works and other introductory texts. If we zoom forward from the late 15th century and the early 16th century to the start of the 17th century, there's a very clear recognition by common lawyers that their books are now mostly printed. A common lawyer in around 1610 could claim that the legal profession learned their knowledge from printed books. There's a sort of study guide, a reading list almost for law students printed in 1600, has a list of books you're going to need to acquire or at least look at in your legal studies. Every single one of those is printed. If we read the autobiography of Sir Symonds d'Ewes, which I wouldn't necessarily recommend, but if you do read that, conveniently he was a law student in the 1620s. And he, at various times, talks about the things he was doing as a law student in the 1620s, one of which, and which he stressed particularly, was reading various law books, all of them printed, as the core of his legal studies, although he did admit that he found the task of reading these printed books difficult and unpleasant, which is something that my students would probably agree with. Despite them being difficult, though, people needed to use these printed books. But if the printed books are so central to common lawyers' learning by 1600 or thereabouts, why did Matthew Hale, who died much near the end of the 17th century, consider his manuscripts to be treasures particularly worth bequeathing? He's not alone in bequeathing manuscript law books to people. He's unusual in bequeathing his own works in manuscript to people. Most people have a collection of other people's writings, as you might expect. And in fact, Lincoln's Inn and many other repositories now have large quantities of handwritten manuscripts of legal material from the period after the onset of printing, particularly up to the outbreak of the Civil War in 1642. And that's really going to be my end date. The Restoration hasn't been investigated as much as I think we would like. And these manuscript texts are very varied. We have law reports, we have treatises, we have unofficial collections of court orders, for example, and particularly for what we think of as the equity courts. And then there are various other things too. If lawyers are learning their law from printed books, what were those manuscripts for? Who was acquiring them? Why? And for that, we need to have a bit of context. The 16th and 17th centuries were a period of very dramatic legal change in England. Very significant developments in many legal fields. There are some areas of law which hardly existed at the time that Littleton was printed in the late 15th century, but were incredibly important in practice by the outbreak of the Civil War. The traditional example of this, and it's a traditional example because it's a very good example, is the law of trusts, uses as the precursor, and then trusts themselves. We could also put, let's say, the law of mortgages into that category as well. Littleton's tenures, for example, hardly mentions uses, the precursor to the trust, although Littleton did leave some of his land by will, subject to uses. But by the outbreak of the Civil War, we see lawyers saying that most land in England is held subject to trusts, subject to uses. So that's clearly a marked change. Other areas of the law, they're not new, but they change very dramatically. We can talk about, let's say, the law of contract, or we could talk even about the law of treason. And very, very different areas of law changed significantly over the 16th and into the 17th centuries. And then there's an unprecedented both volume and really scope of legislation in the same period, at least for any reign after the reign of maybe Edward I. You've got the break with Rome done by statute, all the way down to, and I purely picked this example because I like it, criminalizing the impersonation of Egyptians. Core aspects of property law are subject to significant statutory intervention. The possibility of devising your land by will emerges by statute. There's statute about the effect of forged and fraudulent conveyances. There are also new courts. Some courts existed before the onset of printing and become significantly more important. The Chancery, for example. Other courts are essentially new in the period, and some of them then die off. In fact, at the outbreak of the Civil War, the Court of Wards and the Court of Star Chamber, quite notoriously, which I will talk about quite a lot, in fact, going forward. And all of this change and this development and all of these new things that people really needed to understand if they're going to be lawyers was something that people were aware of. They knew that this change was happening. They knew they had to grapple with it. Francis Bacon, for example, observed that the cases of modern experience are fled from those that are adjudged and ruled in former time. And that's because there's so much new law. And he follows on from that we need up-to-date law reports. Bacon acknowledges, given their personal relationship, very grudgingly, I suspect, that Edward Coke's printed law reports from 1600 through to 1616 had served a very valuable purpose in that regard. He does acknowledge that without them, the law by this time had been almost like a ship without ballast. So we have Coke's reports are apparently very important all the way from the 17th century going forward. So we have this 19th century reports of Sir Edward Coke in verse. There is a research project, I think, on Coke's reports in verse, the comic Blackstone that is produced in the 19th century and other things like that. Hasn't been done yet. What, of course, you saw in the early 17th century was much more like this first volume of Edward Coke's reports. This recognition that the law had changed did lead to practical action. We can trace the way some people learn the law. Edward Coke himself is one example of that. And what we can tell from his reading history is that Coke read the most recently printed law books first when he was learning the law. And then he read backwards to read the older material, and he's not unique in that. Symonds de Use, again in the 1620s, he reads Cook's reports from the early 17th century first. Then he reads those of Chief Justice James Dyer, which are printed in 1585, following those. So he reads the most recent material, then he goes back to something that's a little older. Lawyers, in fact, are even warned that they shouldn't use some of the older books in the common law tradition, if doing so would, as it was said, impugn the common experience and allowance in judicial proceedings at this day. If the older books are out of line with the newer law is what you need to use. So contemporary and recent practice and knowledge is preferred and prized. So the common law in that sense, in this period, is a field where you have to face the challenge of staying up to date. And that's a challenge that's faced by individual lawyers, and that's important. It's also, though, if you think about it, therefore, a challenge faced by the book trade that is supplying these lawyers with material. And it has to be said, to a considerable extent, the printed law book trade failed in that challenge. It did not keep up. And there are various reasons for that. Some lawyers were opposed to the publication of at least certain types of legal material in print, where anyone could read it, including particularly unsuitable individuals like the general public. Other lawyers did have different views on that, but there does seem to have been a very widespread reluctance to print certain types of material. A good example of that we can now see by what was available in manuscript includes material on public law, especially public law that might be in relation to the central government, the king's government. Local officials are less problematic. But even that doesn't explain all of the limits on the range of printed law books. Another limit comes from the law book printers. So the printing of law books was subject to a monopoly right granted by the Crown. It's why on this copy of Cook's reports, you can see underneath the name of the printer, Thomas White, there's a little statement with privilege or by privilege, that this book was printed under that monopoly right granted by the Crown, a patent. And the printers generally seem to have been quite conservative in terms of what they printed. They probably made most of their money by reprinting standard works, particularly the works for students, because of course there's a constant inflow of students into the profession who need books. So they produce books for them, which are the same books as they produced for the students 5 years ago or 10 years ago or 40 years ago, in fact. That may have been because it was easier for them and they could keep stock available fairly easily. It's also probably partly about expenses, because one of the largest expenses in preparing a book for printing at this point was what was called compositing, which is setting the type, the metal type, in frames for the pages. So this is an early printing press. You can see on the right, there's a sort of frame and there's a hinge to the right of that frame. You had to arrange your letters for the text in that frame and do that in the way to maximize your use of space. That was considered to be a very skilled job. It was considered one of the most difficult jobs in printing, and it was expensive. But once you printed a book once, you know what the page is meant to look like the next time around. And so it's not as difficult a job to set the type as it was the first time. The first edition of a book is always the most expensive to print. And therefore we don't see perhaps as many first editions as we might expect. So printed common law books just didn't keep up with changes to the law and legal practice. Between 1535 and 1571, there are no new cases printed. In 1571, there's a handful of very detailed reports printed in Edward Plowden's commentaries. In 1585, Chief Justice Dyer's reports are printed posthumously. Those cover cases from the 1530s to the 1570s. And then until 1600, 15-year gap, no more new cases printed. And as an example of the effect of that, in the 16th century, essentially the common law of defamation emerges. It doesn't really exist before about 1500. By about 1600, it's pretty clear what most of defamation law is. We have things like the slander libel distinction. We have the key elements of what you need to bring a claim in defamation. But there were no defamation cases in print. You could not find out about the law of defamation in print before 1585, when 8 defamation cases are printed in Dyer's reports. Those 8 cases cover a total of 109 lines of text. That's it. That's the entirety of the printed law on the law of defamation. It is nowhere near enough to learn what the law of defamation is in that period. Now, I think given I'm giving this presentation at Lincoln's Inn, or at least virtually at Lincoln's Inn, I should point out this isn't a peculiarly early modern problem necessarily. Some of you may remember Peter Millett's 1985 Law Quarterly Review article on the Quizclose Trust. I may be the only person until now who's interested in that article because it has a footnote at the beginning where Peter Millett complains that the printed law reports were not printing significant first instance Chancery division cases. The printed law reports in the late 70s and the early 1980s were not keeping up with practice in the Chancery division. Now, Peter Millett got to complain about this in a footnote in the LQR. You don't get to do that in the 16th and 17th centuries. There's no way of redressing this in public like that. So how did they, in that period, address this problem of the printed material not giving them what they need? In some respects, they carry on doing things that they'd always done. One method for disseminating material more widely was through learning activities in the Inns of Court. In particular, the readings, which are a series of lectures to which question and answer sessions are attached, provided a means to discuss recent developments in the law. And the readings actually change to some extent, we think, in the early modern period, facilitating that discussion of more recent material. And in theory, every member of an inn is meant to attend these readings. So you could almost see it as almost compulsory CPD in a certain way. And we do sometimes see readers in the texts we have of those readings saying that they are reading on a particular topic because they've had a lot of practical experience on it. So they're bringing their contemporary experience to bear to explain to colleagues, or sometimes actually saying, because the printed books aren't adequate on this and I need to explain what really happens. So this is a means to disseminate knowledge, at least within an inn, albeit not necessarily to the whole legal profession. The other practice, and this is a very old practice in the common law tradition, is simply for lawyers and law students to attend the various central courts in Westminster and observe their proceedings, often making their own notes and reports of the cases that they saw. Again, using his autobiography, Simon de Uz, in the 1620s, fairly late in his legal education, several years after he starts, he explains that he's now going to attend the Court of Common Pleas. And he tells us that he produced his own law reports of the cases he saw there, as did other students. Now, so far as we know, Dews kept those reports to himself. So only he got the benefit of them. So that would help him learn the law, but not anybody else. An observation of cases in person could never be sufficient by itself, because the common law courts of King's Bench, Common Pleas, and Exchequer and the Court of Chancery are all sitting at the same time, and no student can be in 4 places at once. There's a whole Harry Potter plot about trying to get around that problem. Some of these courts are all in the same building, they're all in Westminster Hall, but other courts people might want to observe, such as, for example, the Star Chamber or the Court of Wards, were actually sitting physically elsewhere as well. Now, even the judges sometimes suffered from this. There's a delightful little report in the early 17th century where Edward Coke is Chief Justice of the Common Pleas. And he's quite grumpy about the fact that a case concerning a member of his household went ahead in the Court of Common Pleas when he wasn't there. And the reason he wasn't there is because he was sitting ex officio in the Court of Star Chamber at the same time, and so couldn't be in the Common Pleas to see what was going on in this case that touched on his household. So learning exercises, attendance in court, at best, these are partial solutions to disseminating contemporary knowledge. What flows from both of them, though, and which probably does help disseminate legal knowledge amongst the profession, is a very significant volume of circulating manuscript material. Not all of it circulates. Simon de Uz's Common Pleas reports don't seem to have circulated anywhere, and they've now disappeared. As far as we know, they don't exist. But other material did circulate. So what kind of materials in manuscript did early modern common lawyers need, and why? And first one, the obvious one that we're probably all thinking of, law reports. Law reports provide an alternative to personal attendance in court. Now, today we take it for granted that we need access to the latest law reports. Some people were probably diving into that Supreme Court judgment on nuisance yesterday. But actually, needing the latest cases is something that was clearly important from the second half of the 16th century onwards. We're still figuring out quite how much there was a system of binding precedent in early modern England, but there was clearly a strong practice of citing cases and knowing cases in English legal reasoning and legal argument by the end of the 16th century. So knowing relevant cases, knowing the latest cases could be very important for legal practice. I suspect that lawyers, and particularly law students, also needed law reports as a way of giving examples of how to talk about law, legal argument, legal reasoning. This may in fact have been particularly important in relation to statutory interventions. Law reports give us a way of understanding how such texts were to be interpreted. And generalizing from that, we could go more broadly and say another reason to look at court decisions was to understand the practice of the court. Cases here not serving as authorities that you would cite necessarily, but as examples of the way the court acted. We could take sort of Oliver Wendell Holmes's idea that knowledge of law is about being able to predict what the courts will do. He describes as the prophecies of what the courts will do. And a collection of examples from practice would be helpful to some sort of beginning practitioner, or perhaps even a more experienced one, if they're working in a less familiar jurisdiction, to maybe anticipate what might be likely to be done in a particular case. And at the same time, we also do see lawyers referring to what they call sometimes the course of the court, what is normally done in this court, particularly in relation to procedure. And collections of reports would give you really quite a good way of working out what the course of the court was, what regularly happens here. And those kind of different uses of reports, knowing what was decided, knowing how it was reasoned, may explain some of the massive variation in style, in fact, we see in manuscript reports. Some manuscript reports are very full. They have fairly lengthy, sometimes speeches attributed to individual speakers. Other reports are very brief, key facts, outcome, and that's all they really want to include. That's useful for seeing a court's practice, might work as an authority, no help for teaching you how to actually do law. And at the same time as we see these law reports, we also start to see what have been called treatise-like discussions of the law. So this is the period where we see the first treatise-like texts produced on statutory interpretation. That exists in a couple of manuscripts still. We also see treatises on the procedural rules and practices of various courts, kind of expanding often on the law reports. Now, those works weren't authorities, but they did provide guides to practice. And in fact, in relation to one Star Chamber treatise I'll talk about later, Hudson's on the Star Chamber, we have his personal notebook, which is full of lists of Star Chamber cases and what the Star Chamber did in various situations. We also have a treatise he wrote, and we can see how he took things from his personal notes about the decisions the court had reached to enable him to write a treatise, which he then circulated more widely. The Inns of Court material also becomes more treatise-like in manuscript, at least in some instances. So there's a reading, for example, on uses, trusts and wills in Lincoln's Inn in the 1620s, which is essentially a treatise, a textbook-like discussion of aspects of the law in relation to that topic. I wonder whether he actually spoke in that way, because writing the text, it doesn't come across as very interesting audibly. But he claimed it was a reading first, a lecture first, but then became a treatise. And in fact, it's a treatise in 4 books. It's a long work. And he lent this work to other people. And we know that because he actually recorded the loans of these books in his financial records. And that's how important they were to him. He only ever lent the full text to his colleagues in Lincoln's Inn. At one point, a barrister from Gray's Inn asked if he could look at the text, and Sherfield let him borrow the recapitulation, which is sort of a summary of some of the key points, but not the full text. And that may be the same kind of attitude as Hale, that people outside Lincoln's Inn shouldn't look at his manuscripts. It's not peculiar to Sherfield and to Hale, though. There's a reading in the early 1620s on commissioners of sewers, a sort of local official with some very pronounced powers, reading by Robert Callis in 1622. That gets printed later in the 17th century. Callis allowed that text to circulate in manuscript, but he seems to have authenticated these texts, confirming that they are in fact reliable copies, which suggests some very close control. That's not always the case. There is a sliver, and it is only a sliver, very frustratingly thin sliver, of evidence that there was some commercial copying of text from the readings as well. There's much better evidence, though, of the commercial circulation of actual manuscript treatises. So I've been working on the Star Chamber for several years now, and that court was particularly well served with manuscript treatises from the 1580s onwards. The first one is produced in 1586, and there's another one in around 1620. And these treatises set out the scope of the court's jurisdiction, the procedural rules of the court, and the substance of the offences commonly prosecuted there. That's a pretty thorough text. We have one by William Lambard from 1586, which he revises periodically, and we have one by William Hudson. And this is an example of Hudson's treatise. It's a very nice copy, and almost all of the copies are, in fact, very neat, professionally copied. Sometimes have these nice titles at the top. This one's got a bit of pseudo black letter writing at the very top to make it look prettier. The text of Hudson's treatise, and in fact Lambard's as well, the earlier one, each survive in around 50 manuscript copies, each of them, so about 100 in total. That is more than any collection of manuscript law reports from the period. It's about double, in fact, the number of copies of any known manuscript law reports collection, although the Star Chamber may have had wider interest for non-lawyers, which might explain this. And to give you an impression of the amount of work involved in this copying, when Hudson's text was printed in the 18th century, the printed version is 240 pages long. This is not a short manuscript. This is a very long text, which has been copied about 50 times that we have surviving. Presumably many more copies have been lost. Having said that Lambard and Hudson survive in more copies than manuscript law reports, there are still masses of early modern law reports, particularly from the reign of Elizabeth I onwards. Many are unique volumes, certainly not all of them. The best collection of late Elizabethan cases from the Court of King's or Queen's Bench has been identified as the work of the future Lord Keeper, the equivalent of the Lord Chancellor, Thomas Coventry, when he was still a student. That survives in 26 copies. There's a collection of reports from the court called the Exchequer Chamber, which acted, it's not an appeal court, but a reviewing jurisdiction over other common law courts. There are 13 copies of that collection, which runs from about 1590 to about 1600. I am currently editing a collection of Star Chamber reports, so for Selden members who've seen this mentioned in forthcoming publications, I promise I am editing it. In fact, I was doing so this morning, a collection of Star Chamber reports for the first years of the reign of Charles I. That collection survives in 16 copies, 3 of them in Law French, or about 2/3 in Law French, the rest in English. 13 of the copies are entirely in English. And the fullest versions of that collection run to about 50,000 words in manuscript. And there's one of the English copies for you to have a look at. This is a fairly typical copy. And for the Star Chamber, if you were to bring together 3 different collections of circulating manuscripts, you would have a collection that ran and covered most years from late Elizabeth through to 1628. So we had a 30-year period. It wouldn't include every case, but it's very good coverage of an extended period. And all of those reports circulated in significant numbers. We have 5 or more copies for all of those circulating collections. So you could potentially build up some quite impressive libraries of manuscript material from texts that were circulating within early modern England, mostly within the legal profession. And lawyers clearly thought these manuscripts were important. One of the interesting features of these Star Chamber reports is that one copy was acquired by the barrister John Lightfoot in 1636. He dates his acquisition, which is helpful. What's slightly unusual is that by that time, Lightfoot was actually a very well-established Star Chamber practitioner. So we might have thought he didn't necessarily need another collection. In fact, he'd been producing his own collection of reports of cases in the court, which never circulated. It only survives in Harvard Law School's collection. But Lightfoot, in fact, acquires this collection in 1636, and he annotates them very, very carefully. Despite some of the annotations, in fact, being that I was counsel in this case, so you might wonder how much more he really needed to know, but he still read them carefully, sufficiently carefully to annotate them. What's really difficult, you can do all this tracking and tracing of numbers and acquisitions and things. What's really difficult is trying to identify the effect of all these manuscripts on the early modern legal profession and on early modern law. Citations of manuscripts are dwarfed by citations to printed cases. Certainly my impression is that in general, printed cases were preferred in court. This may be an implicit professional practice. It may just be, to some extent, that people just don't attribute a case to manuscript if it isn't in print, but it might be coming from a manuscript. So, for example, in 1590, Thomas Egerton, who at that point is Attorney General, cites the important defamation case of Boughton and the Bishop of Coventry and Lichfield. The case is from 1584. It wasn't in print at the time. It still isn't, in fact, in print. It survives in multiple manuscript versions, possibly because the facts are to some extent slightly scandalous. Egerton, when he cites the case, may have been using a manuscript. Equally, he may just have remembered the case because he was in practice when the case was heard, and maybe he can remember it and he can use it when appropriate. We can't tell from how the case is cited by him where his knowledge has come from: personal memory, an unofficial manuscript text. It's really very frustrating to legal historians that they were so selfish to not think about us. Certainly people thought manuscripts could be important. Hudson said that he wrote his manuscript text, and he certainly delivered a copy of his manuscript text to the incoming new Lord Keeper, Bishop John Williams, hoping to an extent, we think, to explain what the good practice of the Star Chamber was and roll back certain changes which had occurred under Williams's predecessor, Francis Bacon, of which Hudson very firmly disapproved. Sometimes manuscripts made their way into printed texts, as in a bit of a manuscript might find its way into a printed text, and could influence things that way. So William Lambard wrote and produced a printed Justice of the Peace manual. These are the most widely circulating printed law books in the period because there are so many JPs relative to the rest of the legal profession. And in his JP manual, he includes a point about the law of homicide, to which he attributes it to a report by the Judge William Dallison. Now, Dallison died in 1559. His reports were unprinted. They, in fact, were only printed by the Selden Society 4 centuries later. But that single manuscript report made its way into a widely circulated printed book and then became part of the established canon. One area where, thanks to the work of John Baker, we do now know about the influence of manuscript reports is the personal notebook of Chief Justice James Dyer. So he's the person whose reports were printed in 1585, but those printed reports were heavily edited. So the printed reports omitted almost all of the public law material. In fact, we only saw that public law material once the Selden Society printed it. But we now know that there were some very important steps taken in the 1560s and the 1570s in the judges being quite assertive in their use of habeas corpus. And really, this seems to be one of the crucial periods now in the development of the law and practice of habeas corpus as a remedy against unlawful imprisonment. That development in the 1560s, 1570s left no trace in the printed canon of common law works. But Dyer's personal notebooks contain lots of cases about this, including extracts from records going much further back. His notebooks were known to at least two other judges, Sir Christopher Yelverton, and more importantly, Sir Edward Coke. And Coke made extensive use of Dyer's collection of manuscript material in habeas corpus cases before him in the early 17th century. Critics of Coke in the early 17th century said his decisions were excessive, they went too far, pointing out they weren't in accordance with the printed canon. Coke's view about habeas corpus flowed from Dyer through to Coke, and from Coke to the debates on the Petition of Right in 1628, in fact, and then the backing down of the Crown. So that's probably our most significant use of manuscript material in the period. And here, manuscript is particularly valuable because it enabled the recording and circulating of material that would never have made its way into print. The habeas corpus in relation to the central government would just be too controversial to print. And there were other advantages to manuscripts over print in the period. Manuscripts could be produced in smaller quantities than printed books, and manuscripts could be produced probably more quickly than a printed book. However much contemporaries complained, and they did, about the number of awful avaricious lawyers in early modern England, the profession wasn't actually that large in absolute terms. And one of the things about printed books is the smaller the print run, the less profitable it is, because the upfront capital cost of setting the type is the same whether you're producing 40,000 copies or 40. Manuscript books, though, are probably produced bespoke, and so they're tailored very much for the size of the market. And there aren't the same kind of significant upfront costs. You just pay for the scribe's labour in producing the text. And there's some evidence as well that the turnaround time for producing manuscripts was not that long. When I start saying, well, this is a 50,000 word text and you've got to copy out the handwriting, that sounds like it's going to take ages. Probably did, actually. But one of the French manuscripts I'm editing for the Selden Society is unbound. The pages are loose. They've never been put into a volume and sewed together. The copyist of this volume begins each of the law terms for the reports in a new gathering of pages, the sheets that are folded together to make a little booklet, in effect. And if the reports for a particular term don't fill the gathering, the remaining pages are blank. That's really unusual in manuscripts in the period generally, because it's a waste of paper. And paper was expensive, and there were, in fact, paper shortages on occasion in early modern England. So scribes do not generally leave blank space at the end of a text if they have got more they're meant to be writing. And I think the reason they left blank spaces is because actually they're copying this on a termly basis. That's what they've got available. So Michaelmas term finishes, there's a collection of reports, scribes can now copy the Michaelmas term reports. There's some evidence for a late Elizabethan collection where the copying was done on an annual basis similarly. And if that's right, these manuscripts suggest that lawyers might be able to get very recent material in manuscript, very soon after the cases have been decided. You have your Michaelmas term report or Michaelmas term cases. Shortly after Michaelmas term is finished, someone's producing a collection of reports that you can then acquire. It's almost like, for those of us old enough to remember the pre-electronic age, it's like waiting for the latest print version of the All Englands when they came in the little booklets, or maybe those loose leaf updates to practitioner text when they periodically came in. Now, it's hard to say how far this did occur, actually. There's that hint of evidence for the Star Chamber cases, there's the hint of evidence for the Elizabethan ones. The vast majority of our surviving manuscript material has been bound into volumes because that's helpful for survivability. So either by contemporaries or by later owners. And it's much more difficult to assess gatherings of pages in bound volumes. I have had some slightly funny looks from librarians when I sort of start peering at books and trying to work out if I can see how the pages have been folded together and then sewn together in the volume. Most of my notes, I have to admit, simply record that it's impossible to tell. So it's a gold dust situation for finding out about that. So that's a definite positive. If you can circulate your material quickly and you need up-to-date material, this is great. The difficulty is that termly copying can cause other problems. You might lose some of the material. This definitely happened in some of the Star Chamber cases. They've lost the first half of Michaelmas term 1627, which is not ideal. Even worse, they actually replace it with some Elizabethan cases by mistake. But certainly there's that risk that frequent copying of loose manuscript pages, you could lose some. That could be a problem. And that kind of unreliability had other problems as well. The Wicked Bible is the most notorious example of this in terms of printed texts. If we look at verse 14, it's the well-known biblical commandment that thou shalt commit adultery. I believe this is the copy of a Bible that was owned by a former prime minister. But that omission of the word not is actually really common. When you start editing manuscripts and looking at multiple copies of the same text, you see that one thing scribes frequently miss out is the word not. Now, missing out the word not in a law book doesn't carry the threat of eternal damnation. But it does cause the risk of potentially professional embarrassment. It could be more serious than that as well. Let's say you were trying to bring a case in the Star Chamber, you looked at a volume of reports which says this is punishable here, you would bring that case. If it turns out that the word not was missing and it should have been this is not punishable here, bringing a case that was outside the jurisdiction sometimes caused the court to fine the plaintiff for wasting the court's time. Typically, they were fined about £20. My impression at this point, based on the Star Chamber text having some in French and some in English, is that copyists of English language texts were much less reliable or careful than those who are copying from French. Now, there's a larger sample size for the French, so that might be the reason for that. I'm spotting more errors because there are more English texts. I think it's probably because a number of copyists would have looked at French texts and thought, I can't copy this, I don't know what it is. Whereas they look at an English text and think, this is fine, I can copy this, it's just English. Which would explain what we often see, in fact, in the manuscript reports in English, which is absolute gibberish when they're dealing with technical legal terms, particularly if they're in Latin. We also get other errors in manuscript reports, which means they vary significantly. One quite important one is about numbers. Copyists seem to have had something of a blind spot for the figure 0. They're quite happy to add, remove, or just ignore one or more zeros when you're dealing with numbers. Now, in a sense, they're ignoring something that means nothing. But actually, when you're talking about what was the fine that was imposed, or what were the damages that were awarded in a case, it isn't unusual to see, for example, one report saying they were £300 and another report saying they were £30. That's not necessarily very helpful. Scribes also, and this is a standard problem with early modern texts, switch between Roman and Arabic numerals quite freely. And this causes confusion between copyists. So you might see one scribe will write the number 2 using the Roman form, but they'll use lowercase i's, or 2 lowercase i's next to each other for the number 2. Another scribe might see that and think that's 2 number 1s and write the number 11. And then because of the number forms at the time, the number 1 can often be misread as the number 2, so then you become 12 rather than 11 when it started out as 2. Now, this may not be particularly serious, but I do wonder if this is one of the reasons we don't see people discussing any principles or shared practices or consistency in relation to the law of damages or financial penalties in the Star Chamber. But damages would also apply in the Chancery potentially, and maybe elsewhere. Lawyers are simply aware that the texts they have, these unofficial texts, cannot be relied upon to tell them what the court actually did in terms of numbers. The follow-on problem, not to do with numbers, but another problem with manuscripts, is the copying of names. Now, names are not spelt consistently in the early modern period. Edward Coke was perfectly happy to spell his name with 1 or 2 O's and with or without an E at the end. But sometimes you get cases where the names just don't bear any relation to those you see in other reports. So one that utterly threw me when I started editing these Star Chamber texts, there is a case where one of the defendants is the very exotic Sir Sigismund Zinzan. Now, the family is probably from Italy or Albania, and they essentially made their living performing in the tilt yard for the monarch on special occasions. In some reports, Zinzan becomes Linhan, L-I-N-H-A-N. And I must say, in fairness to the scribes, the first time I saw Zinzan in the reports, I assumed that was an error, and that the Linhan I had seen earlier was the correct name. I'm wrong. Sir Sigismund Zinzan did exist. And if you start looking at the actual records related to that case, there are records of the the fine that has to be paid in the Exchequer records. It's definitely Zinzan, but the names are wrong in several of the reports of that case. Scribes also get the term in which a case was decided wrong. That's normally a header at the top of a page, Easter term, Hillary term, whatever. Scribes often don't pay attention to that when they're copying. They pay attention to the main text and not to the header. So the term is wrong. And then they get their pagination wrong as well. Now, manuscripts will have different pagination for the same case anyway, because not everybody's handwriting is identical. So one case might start on page 1, finish on page 3 in one volume, might start on page 1 and finish on page 4 in another volume, and then those errors build up, or those differences build up over the collection. But sometimes scribes just make what look like really stupid errors. So one copy of the Star Chamber reports, for example, in Durham University Library, has the pagination at one point page 69, page 70, page 80, page 90, page 91, 92, 93, and then just carries on as normal, as if absolutely nothing had happened. All of these might sound quite trivial, but they are a reason why people could not cite cases. Because if you were going to cite a case, you would traditionally want to refer to the date when it was decided. You'd need to know the term, and you'd need to know the name of the parties, which may not be copied correctly. And if those two are wrong, not only is it very difficult to cite, you also wouldn't be able to do what seems to have been the gold standard of citation at the time, which is, in fact, to look up the case in the official records. If you don't know the name, or you don't know the date, and certainly if you don't know both or can't rely on both, you will not find that case. It is not possible. Which may explain why people couldn't cite them. They thought, well, I'm not sure that this case, what the name is. So I might just give a very vague, well, this is what we do in this court, having read a report with a name, because that's safer than saying, oh, this is Linhan's case. And everyone goes, well, there's never been a Linhan's case. And then you've got to try and work out, well, actually, I mean Zinzan, but you didn't know Zinzan's case existed, so why would you? All of those are problems with using manuscripts. The other problem, of course, is going to be circulation. Some copies only circulate in a limited fashion. Henry Sherfield lending his manuscripts to 6 people. Dyer's notebook is another example. Coke knew it, Coke used it. When habeas corpus is debated in 1628 in Parliament, John Selden wants to defend Coke's position, but he doesn't know those cases because he's never seen Dyer's notebook. Now, that said, there is evidence of commercial trade in manuscripts. This isn't small-scale copying between people who know each other. These are objects for sale. There's, in fact, a catalogue by a dealer in manuscripts from the 1620s who lists the legal manuscripts he has available for sale. And one wonders are these available for sale or are these available for copying? In which case, is he keeping a stock that people could then buy and another person could buy and another person could buy? An example of this would be the reports of Francis Moore. Now, these are printed in the reign of Charles II. They also happen to include Star Chamber material, which is why I've been looking at them. We have the Star Chamber cases that Moore includes in manuscript. They're in fact a separate circulating collection, which Moore then copies into his own collection of reports. Moore's reports are definitely traded commercially before they're printed in manuscript. And the various copies very often have these kinds of nice, elaborate title pages. Sometimes it's a whole page, sometimes it's an elaborate header at the top of page 1, which may suggest there was actually a single copying house for Moore's reports, imposing a particular sort of house style about what these are meant to look like. Now, intriguingly, one copy, British Library copy, has this at the end of the volume. It's a guarantee from the vendor. I do warrant this book to be full, as much in quantity as any book that I have sold, and to have the same and as many cases and marginal notes as any that I have sold to any man. By me, Lawrence Cragg. Now, assuming that's not just a guarantee for advertising, Cragg's name, one, tells us the name of a dealer in manuscripts. That's nice. And he's familiar with multiple copies of the same text. That's interesting. Maybe that he's in fact responsible for the copies of Moore's reports that we see circulating. And this, the Cragg volume, if we like, also really helpfully at the very top of the first page gives us this lovely bit of information about the purchase of the book. It tells us at the top that it was purchased or acquired by Robert Paynell of Gray's Inn. He's a barrister who joined Gray's Inn as a student in 1619, called to the bar in 1626, went on to actually produce a set of Exchequer reports himself. Now, Moore died in 1621, so it's possible Paynell buys these as a student or shortly after qualifying, perhaps. And according to the note up here, he paid £4 for 9 manuscript quires. Now, if you go onto the National Archives website, they have a price comparator. You can say, how much was this worth in a particular year? What's it worth today? And apparently £4 in the mid-1620s would be about £550 in modern prices. So this is a pretty expensive book in those terms. If we went with a labour theory of value for assessing value, £4 in the late 1620s would pay for about 60 days of work from a skilled tradesman. So good luck getting 60 days of work from a skilled tradesperson for £550 today. If we think of it in those terms, this is a much more expensive volume. Price of £4 in relation to barristers' income is much more difficult to determine. Fees varied widely. By the early 17th century, some of the most successful barristers seem to be earning about £400 a year from fee income. A mid-career barrister in 1611 wrote to his wife expressing the hope that his income for the year from fees would reach £200. Spectacularly better than those tradesmen who are doing 60 days of work for £4. They're on, what, £24 a year. But if a successful barrister is earning £200 or £400 a year, acquiring this book for £4 is 1 or 2% of your fee income for the year on a single volume. Now, Moore's reports are long. This particular manuscript is 906 pages. Cost of copying, therefore, is about a little under a penny a page. That's at the low end for manuscript prices. But even if this is cheap for a manuscript, it's still much more expensive than print. Edward Cook's commentary on Littleton was first printed in 1628. It's about 800 pages long. It's a fairly complicated printed text, so probably at the upper end for cost. And on publication, it apparently went for 15 or 16 shillings, which means that the manuscript of about the same length is about 5 times more expensive than a printed book. So even if we can say, and we can, that manuscript texts were circulating commercially, We do have to caveat that with, but they were really expensive, at least the bigger ones. These are not casual purchases. You've got to have a good reason to acquire these. Now, lawyers did, but they're an expense and they're a significant cost. What happens in the 1630s, just to finish off, is that actually we start to see that in the 1630s, some of these works that are circulating in manuscripts start to be printed, often not by the monopoly holder. They're technically illegal law books. And some of the names of the people who are printing these manuscripts are in fact people who are also known to have been dealers in old libraries. So they may have acquired the manuscripts through secondhand sales of a library. And also people who were known to sell manuscript copies of texts. We've not got any evidence of them selling manuscript copies of law books, but they sell, for example, manuscript newsletters, manuscript sermons. So they may well have had connections with copyists and may have acquired the manuscripts that way. And at that point, the 1630s, particularly in the 1640s and 50s, in fact, the manuscripts that are circulating in early modern England switch and start to become the printed books that are circulating and start to fill up people's libraries at a much lower cost. Thank you all very much for listening. I'm going to stop sharing my screen.
Ian, thank you very much. Ian has agreed to take questions. There is the Q&A function, which you're welcome to use. While waiting for those to come through, I'll ask one of my own, which is this. You made a particular point of stressing the particularly in the 16th century, the thin number of law reports that actually made it into print. Those not of Plowden and Dyer, very high quality reports, but it's notorious that some of them are pretty ropey. So there's a great range of quality. Is there anything that any generalization that can be made either about the selection of manuscripts for print or for the editing that went into them before they were actually printed?
It's a good question and a difficult one to answer. So Dyer was definitely edited. Whether it's edited for quality rather than just cutting, so removing material they didn't want in print, is much more difficult to tell. Plowden is clearly involved in the production of his reports, as is Cook. I mean, Cook at one point apologizes. This is, in fact, for his commentary on Lutterton. He apologizes for the errors because he wasn't present in the printing house this time. So he's exerting control to some extent over the printing. For some of the ones where the author isn't alive, most of the time we suspect it's probably just an enterprising printer has got hold of it. Whether that's because a practitioner has taken it to them and said, this is a good volume or a useful volume and I think you should print it, or whether it's just they have other connections in the book trade and they found it and they go, I can print this, is hard to tell. Certainly we think in the 1650s, when printing is deregulated during the interregnum, it's very much just printers get hold of something and decide to print it. There's a bit of evidence of that for the 1630s as well. And they're not editing particularly. They are just printing what they find. That may be not the case, actually. There's more evidence for editing, weirdly, in the early 16th century with the medieval yearbooks, that there is concern and that they are looking and people are actually putting out competing versions of the same years. And that there they are trying to produce relatively high quality texts. That doesn't seem to happen later.
Does the grant of privilege, monopoly, did that have a sort of deadening effect on the printing of manuscripts?
Not particularly, to start with. So to start with, the first person to get it is Richard Pottle, and he is reprinting the old stuff. but also producing new material. I mean, under Tottle, for example, you get the first printing of the 13th century book known as Bracton. And that seems to have been done at very considerable expense to him. He hardly produces anything else the same year because it's such a big book. So he's certainly willing to take some risks at the time. After Tottle, and actually particularly once you get into the 17th century, the patent starts to be held by people for whom it's a financial investment rather than because they are in fact printers. So the patent becomes held by the company of stationers itself, which then delegates the printing to individuals for particular works, or held by a kind of syndicate of printers. Well, actually, no, technically it's held by a courtier who then delegates the right to use it to a syndicate of printers. And they just reprint and reprint the old stuff over and over again. They're very conservative. They produce a new book once, but only after someone's produced an unlawful copy of it first. Sort of test the market and think, oh no, you can't do that. We're the ones. It's almost like sort of modern IP. We've got to print it now because someone seems to be doing something in breach of our rights. So we've got to instead exercise the rights ourselves.
Yes, thank you. I thought I had a question, but now, actually, one's just popped up. For this from Richard Wallington. I seem to remember that Donne's poems were only circulated in manuscript during his life. Could it be that circulating sorts of material other than law in manuscript was part of intellectual life in the period? That's quite a broad
It's definitely
question.
right. And yes, Donne is a good example of that. There's been a lot of literary work on this, what are called the coterie poets who circulate work amongst themselves, many of them associated with the Inns of Court around 1600, small groups of friends who just circulate in manuscript. And actually, some of the things that we might not think of as circulating in manuscript do. So newsletters, for example. It's one way of telling people what the news is by writing them a letter, but these letters are clearly understood as not limited to the recipient, that they may also circulate these letters more widely, either reading them out or passing them on to other people. So you sometimes see instructions such as, don't communicate this bit. Circulating things by manuscript is very common in the period. We don't have the same kind of evidence, unfortunately, for some other sort of learned groups. So physicians, I'd love to know more about civilians and their manuscripts and circulation, but there just isn't as much material, sadly. Lawyers have the benefit, certainly for the bar, of course, that they're very concentrated in London. So we can see it more easily. And there must have been manuscript circulation of sort of samizdat material among communities that can't get it printed or shouldn't get it printed. That's a different type of underground publication, I suppose.
Thank you.
Nick, can I ask a question?
Oh, Philip.
Yes. What information do we have as to how extensive were the libraries of the Inns of Court? Could that be a repository for manuscripts?
The catalogues for that early are mostly non-existent. We have some evidence of some acquisitions, but not many. Actual manuscript collections at the inns, so far as we are aware, didn't exist, although one would suspect they might have had one or two, or there may have been gifts occasionally. Printed books tend to be given as gifts. Manuscripts less so. I do wonder sometimes if that's because printed books, in a sense, look more impressive often than the manuscripts. You always have that very nice title page with all the nice grapes and columns and all the rest. It's always grapes and columns for law books stuck on the front, framing things. You don't get that in manuscripts so much. You do. There's a very odd manuscript in the Huntington Library, which is it must have been intended as a presentation copy of Littleton's Tenures to be given as a gift to someone. Now, that's utterly confusing because Littleton is so frequently reprinted. There's hundreds of those books around. But we can tell it must have been a presentation copy because it's missing the capital letters at the start of most chapters. So presumably the intention was to add either a rubricated or maybe even an illuminated handwritten letter at the start of these chapters for a book that's already in print. But that's very unusual. People give gifts of printed books much more frequently
Well, what I thought. Oh, sorry, Ian.
That's right. I was just going to say Dunstan may know more than me on that. Lincoln's Inn and could correct me.
What I thought was the first question actually says, no question, just a fascinating talk. Thank you, which I'm sure we can, we would all agree with that. Ian, you've got a terrific breadth of reference and reference in detail. You've squeezed every drop of juice out of your material. You've made a coherent account out of what on their own must have been very disparate facts and observations. So we've ended up with a well-constructed and fascinating story, not to mention the excellent and very well chosen illustrations. So we're really grateful for the care and skill that you've put into this talk, and thank you very much. I'm so sorry that the IT won't allow us to clap you, but consider that a virtual applause. Thanks very much indeed.